Okay, thank you everyone for being here today, live at the hall at our institute and online. So it's my pleasure and honor to introduce our guest today on the Philosophy and Psychiatry seminar. That is André Exter. He's an associate professor of health law at the Erasmus School of Law at the Erasmus University of Rotterdam, Netherlands. He holds a PhD in law and was a holder of the Jean Monnet Chair of European Union Health Law. He has also held several visiting professorships in international universities across Europe. He has also published several books and articles on European health law and covered the main aspects of health law from a European perspective. Today, André will talk about a topic that is titled Disabled Persons and the Right to Health. And please, André, the floor is yours.
Thank you very much for the kind introduction. Let me first go to the first slide. Well, as mentioned, yes, working in Rotterdam Erasmus University. My field is health law, and a particular interest is about one of the core rights is the right to health. So what is the meaning of a right to health? This is also within our teaching program, and within that program, we also focus on specific and so-called vulnerable groups, like women, children, but also the disabled persons. So disabled persons as today's topic for this session. In the meantime, if there is something need for clarification, if you would like to add to discuss some things, please intervene for those who are listening. So more than willing to have that discussion also in between and not only in the end. For my understanding, what time do I have?
45 minutes to an hour. We have plenty of time.
Okay, so that's good to know in advance. So the question is, what the focus with the right to health and health care and disabled person. I will start with the theoretical framework from an international law perspective. That is to provide some clarity. And then the emphasis is also on a more regional level, so at European level, and specifically dealing with the European Human Rights Court. I'm not so sure about the audience background in the field of law, but let's see how and depends also on the questions and remarks, but let's see. So this is more or less my outline from the international treaty law, from UN level, the Convention of the Rights of Disabled Persons, abbreviated, and then the second part about how does the court deal with this vulnerable group in order to protect their right to health. But first, let me start with the convention. So we have a global law convention. No, let me say in advance. First, there are already many human rights treaties protecting the rights of human beings. And in addition to these general treaties, we have some specific treaties for vulnerable groups, like the disabled persons. So starting that debate is, why do we need a separate additional convention? Well, there are several reasons for it. First of all, the number of disabled persons on a global level is more than 1 billion, roughly. But also an important reason to draft such a new text is also because these vulnerable persons face discrimination and stigma. So the idea of this convention is first to confirm the rights as already accepted in previous conventions, but also in order to promote and to protect their rights in all areas of society, not only at work, at home, but also in all kinds of participation in society. That's meaning the full and equal enjoyment of these persons in life. Having said that, that means that it's nice to have such a piece of paper, but it creates, what does it mean? Well, first of all, it creates positive, so-called positive state obligations to member states who have ratified the convention. They have to take a variety of measures, not only legislation, but also to draft policy documents and all kinds of other measures in order to facilitate to a maximum of its available resources. And that means that given the fact that there is a huge variety among member states of budget available, that there are differences in approaches and also differences in levels of protection. But the ultimate aim is to realize the full realization of all human rights, which remains rather vague, I must admit. No. So, to which category? And that refers to the what are considered as disabled persons, who are considered as disabled persons. The convention or the treaty does not define that category, but roughly it is understood as those people who are, due to their disability, mental, physical, or intellectual disability, face restraints in the communication, in the interaction with third persons. That is a very broad category and a rather flexible approach it has therefore taken. So, what does that mean when I focus to the right to health? The right to health, as said, has been mentioned in general UN treaties. And here it has been confirmed also applicable to disabled persons. And it remains a rather vague definition, the highest attainable standard of health without discrimination. That is the core obligation of member states. It means that member states, state parties, will take measures to ensure and the same range, quality and standards and free of affordable healthcare. That is a crucial obligation towards nation states when they have ratified the convention. How they organize it, that's up to them. So they have a rather freedom and a margin of discretion how to organize it. But ultimately, this should require, in the long term, the same range of quality of standards of care, and without discrimination. So that is an important statement made, but then we also know that it can be quite controversial. There are controversial issues, like, for instance, sexual and reproductive rights. The right to health also includes sexual and reproductive health, so access to these kinds of services in general, and therefore also for disabled persons. But we know that, for instance, the example of contraception and sterilization against the will of this disabled person has happened in the past, and sometimes even on contemporary basis. So these rights or practices may violate human dignity and may therefore also violate the right to health. But how should we approach it? What does it mean? Because it may cause major dilemmas when we talk about when the example of intellectual disabled persons, a couple who would like to raise a child, to start a family. Is that allowed? Is that allowed by national law, or should it be restricted for certain reasons? This may cause a dilemma, and for that reason, certain nation states have made some restrictions to that right to health and right to sexual and reproductive health, access to these kinds of services, in all kinds of reservations and interpretations made. So here we see differences among member states with respect to particularly with respect to the controversial issues of abortion, contraception, and sterilization. That is an serious concern. And when we talk about the right to health and right to access to healthcare services at national level, we shouldn't forget that these rights are interrelated and interdependent, meaning that they are closely linked to other rights, like the right to life. Take, for instance, the example of a comatose patient or disabled patient in a vegetative state. Should we treat this, and to what extent is this a lifelong artificial treatment, or should we end this life? So what is the meaning of a right to life when it concerns to these vegetative state disabled persons? It may even become inhuman and degrading treatment to continue treatment or even to end treatment. So that means that it's not only the right to life is at stake, but also the prohibition of inhuman and degrading treatment or even torture, as mentioned. And that has been some concrete examples are dealing with isolation, sexual abuse, and medical experimentation. In the second part, I will give you some examples about whether or not these actions or these treatments can be considered as inhuman and degrading treatment or not. So, without consent, it seems at first take that could be considered as a violation, but there can be justifications in order to justify these kind of medical interventions. But the question is, what can be that justification and what are the circumstances? So I'll give you some examples hereafter. So finally, about the conventions, it is nice to have such a convention which has been ratified, but it needs to be monitored, to assessed and monitoring, starting with monitoring. So there is a treaty monitoring body and which reviews the periodical state reports in which the states clarify what kind of steps have we taken in order to improve the human rights of the disabled persons in this particular country. So each of the member states will present and produce these reports, and the committee will review and assess based on the convention's rights whether the state has been successfully or not in order to realize these rights. So that's an important instrument, the monitoring, to assess the progress made by member states, by the committee, and even by the special rapporteur who may visit these countries. And also national human rights institutions play an important role in this monitoring process. And it shows that also in my country, one of the slides, it appears that the Netherlands, for instance, has remained unsuccessful in order to protect the rights of particularly of mentally ill patients, as I will explain later on. So there is, apart from this monitoring, that remains, there are no sanctions involved, but an alternative sanction could be the so-called complaint protocol. And that means that individuals may initiate ultimately a complaint for this committee of the convention, this convention committee. And in case of a complaint, and such an example is the Swedish case. And in the Swedish case, it was as follows: a person who was a severe muscle disease, degenerating muscle disease, requested for building a pool at home, so at their own property, but which was denied by the local government. And this indoor pool was for medical purposes only, for rehabilitation purposes that might help her to have some kind of reasonable life. But that was refused by the local government and said that would not fit the building requirements of this community. So for that reason, it was denied. And as a result, rehabilitation was impossible for her. So this was submitted to the committee as a complaint, and ultimately the committee, the treaty committee, ruled that this was a discriminatory measure. The denial was discriminatory and disproportionate. So the meaning that the local government had to allow this person to build a local and indoor pool at their own property. But there is no sanction mechanism included, so no penalties are included for certain specific political purposes. But it illustrates it is an authoritative committee in its decisions, and therefore most member states will reply and respond and respect also these outcomes. So it is more a quasi-judicial body, but it's the effect of its rulings is also important, and therefore allowing individuals to protect their human rights as disabled. So when we talk, even when we have this treaty, when we have this monitoring bodies also at national level, there are many examples in which the rights of disabled have been violated severely on a serious level. Very recently, this is just one example of such a human rights scandal. Last week, the New Zealand government apologies for a long-term abuse of adults and disabled children. So this is just an illustration that the rights are not fully protected. Similar counts for Cambodia. Mental health in many countries remains a taboo. So therefore, these disabled persons are isolated, stay at home, and nobody talks about it. So there is definitely a need to improve that situation. This example is a Dutch one. For not so long ago, 10, 20 years ago, intellectually disabled persons were chained for a long period because the staff didn't know how to treat them. So they were chained not permanently, but for long periods of time, because we didn't know how to do, because they were unable to treat them. This is a practice which has continued for many years, and ultimately resulted even in a detention and a penal case where these intellectually disabled persons were abused. One of the rare occasions that the penal court had sentenced the staff members into prison. And here another one in the UK. So it's not unique to Asia or Europe. It happens, unfortunately, on a global level. There are many examples of these excesses of human rights violations. So what to do? What to do? Monitoring, complaints is an issue. And more specific at European level, as the final court, there is the European Court of Human Rights. And if you are familiar with this court reviews and assesses the European Convention of Human Rights. But the European Convention of Human Rights, you should know, does not include a right to health. A right to health is considered as a so-called social right, whereas this convention only includes individual rights. But that doesn't restrict the European Court from reviewing and including the right to health into individual rights. It has found a solution or a way how to assess a social right under the convention. And that is quite remarkable because this court has extended the interpretation of individual rights as incorporating so-called positive state obligations. That might seem rather vague, but let's take an example. The right to health means first and for all that the includes a negative obligation, so to abstain from unlawful interference, so to abstain from unlawful killing of citizens. That is a core obligation. But at the same time, such a right to life may also include positive state obligations. And we can apply it in the healthcare sector. And for instance, a right to life requires states to provide proper healthcare facilities. Otherwise, its citizens will die. So by extending a so-called negative right with incorporating positive state obligations, it allows this court to assess the right to health under its convention. And there are numerous examples in which that strategy has been applied and even accepted. So let me give you some examples hereafter. With respect to the right to health, particularly these articles are relevant with respect to right to life, prohibition of torture, liberty, and private life. I will skip the Oviedo Convention for this moment, but I focus particularly on the case law dealing with human rights violations. And a good example of such a violation is the Valentin Campanau case versus Romania. Here, all of them are tragic cases, but this is particularly tragic because it concerns a minor, an orphan, who was disabled, mentally disabled, and also HIV infected. And due to the stigma of HIV, the medical staff was unwilling to provide proper and provide medical care to this minor patient. And ultimately, it resulted in death. The patient died due to the lack of medical treatment and stigma. So here, the court concluded that by the denial of providing proper health care to Valentin, it meant that the Romanian state failed to protect his right to life, and therefore it was concluded as a violation of Article 2. And that approach is actually returning and repeated in other cases, more or less similar. Vulnerable people, intellectually disabled persons, unable to communicate and chained for a long period of time. And as a result of negligence and abandon, he died without proper health care. So again, as assessed by Article 2, creating positive state obligation to provide the basic health care, and that was denied. And as a result, this patient died of pneumonia and was considered a violation of Article 2, meaning that Hungary failed to protect those who are under custody or under the protection of the state. But it's not only Article 2 that is at stake and has been addressed. Also, cases, there are many cases dealing with Article 3, so inhuman and degrading treatment. Even in healthcare, torture or inhuman and degrading, some actions can conclude it as torture or inhuman and degrading treatment. It's not only about waterboarding, but the absence and the denial of proper healthcare can indeed be considered as a violation of Article 3. So here you see the situation, the circumstances, disabled person, institutionalized, and also chained for almost 2 years. Can you imagine, for such a long period, because there was a risk that he would leave the institution, chained and no proper medical care. And what is particularly relevant is that the state authorities were informed about this maltreatment. So the state authorities were aware of the lack of protection of this patient. And as a result, that was again concluded as a violation of Article 3 of the Convention. But it can be even worse. Similar examples, a recent one in Moldova, and even this morning I just read another case, more or less similar case of a psychiatric patient also in Moldova, and the lack of treatment and also the lack of a legal framework. So involuntary admission and treatment requires a legal base, because it is otherwise it could be considered as a violation of human integrity. Without a legal base, involuntary treatment is not allowed, meaning that there is, first of all, a medical need, a medical necessity in case of dangerousness. The dangerousness criterion should be fulfilled. If that is not set by law, then actually no restrictions are allowed. And that was the case more or less in Moldova, and not only on an individual level, but also it was even concluded as a systematic problem. So absence of proper legal of a proper legal framework, without the absence of legal remedies to complaint, was considered by this court as a gross violation of Article 3. And therefore it urges the Moldovan government to improve the situation, to develop legislation and in terms of involuntary admission and treatment. And I can actually continue. So a variety of rights. Article 2 can be applied, Article 3 can be applied, but also the right to liberty, Article 5 under the Convention. And that is also referring what I mentioned, the so-called dangerousness criterion. So involuntary admission in general can be allowed when there is, of course, a psychiatric disease, and there is a direct threat of his health, the so-called dangerousness criterion. But if that hasn't been identified, you do not fulfill the conditions for involuntary admission, and therefore this admission is unlawful and violates therefore the right to liberty. And not only for admitting in the hospital, but also continuing the treatment. There are many, many cases in which the court has set the rules that, first of all, there needs a clear legal framework for mental admission, treatment, and continuation of the treatment. And continuation of the treatment must be reviewed by a judge, an independent court, and also assessed by a medical expert, the so-called psychiatrist. This is purely case law, and as a result has been included in national law. So that is an important step in which the court has addressed these rights. When there is a treatment provided, so admission should be followed up by a medical treatment, a proper medical treatment. And sometimes, on rare occasions, these patients may participate in clinical trials or clinical research. But this is really a sensitive topic to include vulnerable people who are cannot express their will to let them participate in clinical research. For that reason, it is required that a legal representative will explain and provide consent. But when it's involuntary, without consent for a new drug, that is indeed, again, a gross violation of the convention itself. Therefore, not allowed. There are some examples over in emergency situations. You can imagine that even when there is an involuntary admission and a treatment, there can be an emergency situation when a patient becomes violent. So to restrain and to lock him in a room or to a bed. But these restraint measures, immobilization measures, are most intrusive and therefore can only restrict for a very limited time. In this case, the Engerholm case, he was restrained for 23 hours because there was simply a lack of staff was available. And that argument has never been accepted by the court. A lack of staff, lack of personnel does not justify such a long restraint immobilization measure. It can only for minutes, maximum 1 or 2 hours. But 23 hours is not considered as strictly necessary and needs no cannot be justified. Therefore, is considered again a violation of Article 3. So here you see that the court defines the conditions, what is allowed, what is not allowed under the conventions. Engerholm has been confirmed also in a recent Italy case, 8 days compulsory hospitalization. Without a medical treatment and purpose is not considered as strictly necessary, and even refers he to the so-called the prisoners' rules, which are not legally binding, but has been applied in order to define the conditions for psychiatric patients. Well, that having said, what another issue, tragic issue, concerns the suicidal patients. It is extremely difficult for health institutions to prevent suicide, but it may happen. So that means that states and institutions do have a special obligation to protect those vulnerable patients. But sometimes it is unavoidable. So the question is, what kind of reasonable steps can a state make or do in order to prevent suicide? And that is the criterion that has been applied by this court on several occasions, as you can see on this slide. Are there what are the reasonable steps to be taken? And that refers to, first of all, what do we know about this patient? What is the medical history of this patient? If it is in the medical file already mentioned that he had already taken several attempts to suicide, then it requires more strict measures of the state to prevent further attempts. But when this medical file or this information has been ignored, not applied, then it means that the member state has failed to protect this person from committing suicide, therefore also again considered as a violation of human rights. Ladies and gentlemen, I've bombarded you with some examples of cases, and it might be puzzling, but I also would like to address some dilemmas, even when we have this Court of Human Rights able to assess human rights violations of disabled persons. clearly member states do face other problems. I already referred in the beginning to waiting times in mental health. The UN monitoring body particularly identified the problem in the Netherlands, and I guess that is not unique to the Netherlands, that waiting times, lack of staff, lack of institutional places for treatment, which may deteriorate the health situation of mentally patients as a major problem. So we should do more, not only in terms of funding, but also to attract staff for providing mental health care. A second issue which remains controversial and difficult, what to do with mentally or intellectual disabled persons who would like to start a family. That is a fundamental right, also applicable to disabled persons, but at the same time, there can be, that may cause a dilemma because they cannot afford and they cannot protect and raise the children themselves. So, can reproductive care be restricted for those with an intellectual disability? And raising the question, can we even force the use of anti-contraceptives? Remains questionable. And finally, maybe unique to those countries who allow euthanasia and assisted suicide, we even face, also in the Netherlands, there are examples of intellectually disabled and mentally ill patients who request for euthanasia, and it has been accepted on rare occasions, I must admit, but this is although it was particularly aimed for the more somatic patients with, let's say, cancer patients. But this has been extended, and therefore also those mentally ill, these intellectual disabled persons may request for euthanasia, which is, and again, a controversial issue. So that leads me to the following conclusions, that we have seen that clearly from international and regional level there and national level in most countries, there's a range of norms, a legal framework to protect the persons with disabilities. And a key issue is about here addressed about equal access. But still there are many examples also raised for the court in which the discriminatory aspect of behavior and the treatment remains an issue. So preventing them from access is therefore a key issue and cannot only be solved by lawyers, as I must admit, but it is one of the disciplines which may contribute and to make it more acceptable. So far, my questions, ladies and gentlemen.
Thank you, André, for this excellent presentation, but laid with very, very hard and heavy case studies that you have presented here. We open up the floor for discussion. Please go to people here and also for people online. So first we have one question here from the audience at the Institute.
Hello, André.
Hi, hello, Marta, and others.
Related to the audience, it's lawyers. There are lawyers here who understand what are you talking about. I hope. Well, I wanted to ask you to get back to the CRPD article.
Yeah.
Specifically Article 12, legal capacity. I mean, it's equally relevant to it is equally relevant to right to health, right to life, right to legal capacity, and sometimes it's even conditioned for what you emphasize, the voluntary, involuntary hospitalization measures and so on. So, but it's also, at least in our country, as it is defined in CRPD, it's quite disputable. CRPD is adopted by our government through the law, so
Yep.
it's now national regulation, not international. And I know it's your lecture was focused mostly on the right to health, but when we are talking about people with mental illness, we have to refer also to the legal capacity. Now, in our national regulation, aside of CRPD, we have division between legal capacity and business capacity. Legal capacity you gain by birth, and business capacity you gain by adultness, 18
Yeah.
years, or partial legal capacity with 14 years. So, but in CRPD, it is said just legal capacity, which I assume, according to some Anglo-Saxon notion, is joint legal and business capacity. So the point is, I'm not sure whether in front of European Court of Human Rights, it was ever interpreted what is legal capacity. Is it capacity for reasoning in general? Is it capacity to decide on to sign the contracts? Is it capacity to decide on your own health? Is it capacity to give the consent or not to give the consent? It is very problematic in our national legislation how to interpret legal capacity from European Convention of Human Rights, from European CRPD, when we match it with our national regulation. Is it actually just fluently, just abstract capacity for reasoning? How do we interpret it? What do you think? How would the European Court of Human Rights interpret legal capacity in these cases when it decides on the right to give consent, to voluntary or involuntary admission, and so on? I mean, it is quite disputable, if you understand what I mean.
Yeah, I think so. Thank you very much, Marta. I am now thinking about whether or not the court has dealt with that issue of legal capacity, or at least interpreting legal capacity in a way. I can imagine. So there is. I can imagine that it leaves it up to the member states for how to interpret legal capacity in such. It's to my knowledge, in these cases of mental health, it is just referring to national law, and in that when it concludes that there is let's say a mental disability at stake. And I'm not so sure they will define what is the meaning of a legal capacity, but that is something I have to check myself also, because it's not quite clear. I can't remember any cases in which they have defined what is the meaning of legal capacity. They just assume, to my knowledge, that there is a person of unsound mind and therefore needs to be represented by a mentor or something like that. But that is.
It would be. Do you assume that if it would be initiated in front of the European Court of Human Rights, your court would align with the national regulations and national understanding of legal or business, or what is legal?
Most likely, because I know what you started with the CRPD. I know that the CRPD is in a way controversial for many countries, because the CRPD actually does not accept, the convention doesn't accept involuntary treatment option. So, and that also refers to capacity. The idea of that even mentally ill cannot be treated for against their will. And we know that is not in line. There is different interpretation under the European Convention of Human Rights. We have seen the examples which involuntary treatment might be justified when there is a legal basis, when it is necessary and proportionate, blah, blah, blah. So that concept of involuntary treatment is not necessarily accepted under the international covenant. So perhaps that could be a reason that this European Court refers more to national interpretation and leave it up to the member states.
Okay.
That would be my first answer. I'm not quite sure if that is completely satisfying to you, Marta.
Yes, it is, because there is a quite hard push from, let's say, civil society organizations to interpret legal capacity in the sense that it is capacity for reasoning, actually, and that you require from every person just a bit of capacity for reasoning too. But as you say, just a bit of capacity, and therefore, as a consequence, a consent. And we are aware, if we are real, that if we talk in the real frames, that not every hospitalization can be voluntary. Some hospitalization in the sense of in the context of public wellness or something, there are interests that contradict voluntarism sometimes. If we are talking really in the real frames, not just imagining human rights and personal rights as absolute rights, because they are not absolute, they are
relative
with other personal rights and the public interest. It's obvious that legal capacity is not giving everyone capacity for reasoning if there is not ground for doing so. So that's why I wanted just your thought. How would European Court of Justice interpret?
Well, I think what I said, and I think that leaves a margin of discretion to the member state, similar as the meaning of life and age limits. That is also not, the court doesn't make it explicit what is the minimum level for adulthood or something, or when this life starts. That's too controversial. That kind of issues need to be decided at national level.
Yes, thank you, André.
Thank you, Martha. Thank you both. I think this is very interesting, very relevant question, but also has a great philosophical significance. It's a hard philosophical question that needs somehow to be not answered, but decided on certain terms before we move on to legal legislation and any kind of legal decisions regarding this kind of a question. But it does have to be addressed in theoretical terms before we get to like the ground level problems. And it seems like a very abstract problem. Again, as you say, it would be like a philosophical problem. What are the reasoning capacities of a certain disabled person? But that is not something that can be established on every case when it happens in a certain medical institution on a certain day and time, but it has to be like predetermined before that in the legislation, in the law itself, so people can act in a certain way. At least to have a broad framework, what it means to have reasoning capacities or different levels of self-consciousness or something like that. But I think this needs to be more unpacked, more better understood at a higher level of legislation, like you asked. I think it's a very important question. Do we have any other questions from people here or online, or comments? maybe on certain cases that happened in Serbia that seem similar to this, if you know any?
Well, we had quite situation maybe 2 years ago when a Mental Disability Rights International, Serbia published a publication where on the situation in the institutions for children with mental health disabilities, how they are treated, and it was, I mean, it was. I'm not sure whether the case was initiated in front of the Court of Human Rights, but it should have been. It should have been, because it opened many issues, how they are trained and so on. I mean, I don't want to blame my country here, but
No, but it's not unique.
like,
I also showed one of the slides was about the Netherlands.
Yeah.
Even in the Netherlands, you see, and even last week, because I showed you the Danish case about what immobilization and restraint of maximum 23 hours or 8 hours in Italy. Even in the Netherlands last week, there was the healthcare inspectorate intervened in a psychiatric institution because they held a person isolated for 7 months. 7 months continuously isolation of a psychiatric patient. That, well, how is that possible? And clearly there can be a reason, but for therapeutic purposes, that is never be justified. For the prison rules mention minutes, maximum an hour of isolation or immobilization, but definitely not for days or even months. So here you see similar examples, unfortunately, occur in many countries who have ratified the convention, and so there is a need to make this public and to make it, and also let courts decide, and even the inspectorate to intervene, because it is well, a serious issue. Yeah.
And I just wanted to comment also on this case when where you said that the state is not responsible for preventive or
suicide.
Yes. So I read one two-level or two-level verdicts of German courts. So Land verdict and
Yes.
Bundes verdict,
In appeal.
where the patient was under LSD, so it was let's say he was
A
not
drug.
that
Yeah.
concentrated, and he tried suicide. He was accepted in the hospital for some break of leg or whatever he managed to do to himself. And since the hospital had several stages, levels, let's say 4 or 5, he was not under supervision. He threw himself again into this short.
He dropped out. Yeah.
And he tried suicide again. And hospital was in 2 levels, guilty or not guilty, but liable for not taking care about the patient properly. So I mean, these are the verdicts maybe about 10 or 15 years ago, but maybe
still relevant. Yes. And you see, Marta, also the court rules that what can we reasonably expect from a state to protect your patient? And as what I said, if you know the medical file that he has made several unsuccessful attempts of suicide, then he should not be present on an open, but he should be placed on a closed ward, so to say. And all kinds of additional security measures, safety measures should be provided in order to protect his health, because that is also a positive state obligation under Article 2 under the convention. And if you do not provide them or not sufficiently, then it is not an excessive measure, then you can still conclude that apparently the state failed to take reasonable measures. You cannot prevent them 100%, but reasonable measures you may ask. So clearly the question is then, what is considered as a reasonable measure to protect health? Yeah. Depends on the on all the circumstances, I would say. Yeah.
But on the end, maybe you can discuss also the state, his state of mind. I mean, in his state of reasoning. If he tried it 3 times, it was probably how do you say it's not his ad hoc decision. It was decision that he thought over, and if he was legally capacitated, I mean, it's his decision.
So you cannot always prevent it, but and that remains an issue. I agree with you. Yeah.
But I wonder sometimes whether this European Court rulings have back effect on national rulings. We would have to check whether Germany changed its path or not.
Well, that is the most difficult thing, and that's a little bit out of the scope of our research, of course. So we focus on what is the outcome of this ruling. So, and then it may result in a changing legislation or changing in policy. We don't know. But ideally, you hope that at least there is a discussion about how do we treat involuntary and how do we cope with involuntary treatment options. What kind of options should we regulate it? What is the role of the health professions? Is it being discussed? Are there adequate legal remedies if they disagree with the treatment? So that is all kinds of, these are extremely important aspects, and they may be triggered by an outcome of the court. But that is, that is a different aspect. But I agree with you that it's also imminent and crucial to know.
Thank you, André.
No, more than welcome.
Hope to see you soon.
Yes, let's meet.
Thank you all. Yes, it would have been nice that you were here together with us for a live talk. So do we have any more questions or comments from people online or here? If not, let us thank André again for his excellent talk. Hope to see you soon again on our seminar and here at the Institute.
Yes, who knows? And otherwise, well, thank you also for listening and for contributing to the discussion, which was really great also for me.
Yes, thank you. Thank you, everyone, for a great discussion. I think we had very interesting points today that went into a philosophical discussion, but on the law kind of side of the problems. Thank you again, everyone, for being with us today, and see you again for another seminar of philosophy and psychiatry.
Yeah. All right. Have a nice day.
You too.